Lawyers are known for one thing. They want to fight.
If he says 2 plus 2 is 16, I believe so.
Be curious, not judgmental. What's wrong in lawyers advertising themselves?
The law can be advertised, not the lawyer.
They say you're a threat for lawyers. If all the people start skipping that court hearing phase, don't you think it's like directly attacking the lawyers who's making bread and butter?
It's the other way. In fact, I would say it's a double advantage.
Mediation should be done by two people who are willing to mediate.
Compulsory you have to go to a shop, but buying is free. Entering the room is important. Court, you have no choice, it's compulsory. In mediation, you can choose not to go.
I have two numbers for you today. 4 crore, 82,000 and 83,000. Let that sink in for a second. 4 crore 82,000 cases are stuck in Indian courts right now. And 83,000 of them are stuck in Supreme Court alone. We all know the saying, justice delayed is justice denied. But in India, justice isn't just delayed, it's stuck in traffic. Buried under paperwork, dragging on for years. I am Arsha Prabhakar and welcome to our show Coffee with Counsel. We invite India's top legal minds to simplify law and break it down for you. You've seen a meme, right? A jungle full of animals running. The elephant asks, "Why is everyone running?" The tiger shouts, "They are arresting all the foxes." The elephant, confused, says, "But we are not foxes." And the tiger replies, "Exactly, but if we get caught, it will take 20 years in Indian court to prove it." The elephant starts running as well. That's our legal system. Slow, messy, exhausting. But what if I told you there's a way out? A way to skip the delays, cut through the chaos, and solve disputes faster. It's called mediation. And it just might be the future of justice. To break it all down, we have Prasanth Chandra sir with us today, a lawyer for over 35 years, a certified mediator, and an expert of dispute resolution. He is here to explain why mediation is the next big thing and why it should change the way we think about justice. So, if you have ever wondered why court cases take forever and if there is a better way, this episode is for you. Let's get into it. Welcome to our show, sir.
Namaste.
Namaste, sir. Thanks a lot, sir, for joining our show. Usually, my first question for the guest will be, how did you come to the law? But I have one more different question for you, sir. That is, lawyers are known for one thing, that they want to fight. They are like hardcore litigant. They want to go to the court. They want to sue the people. They want the best justice for their client. But being in the fraternity from past 30 years, you chose to do the exact opposite way. That is, you're trying to find a middle ground between two people who are fighting for justice. What made you to choose such a different path and for doing it for the same consistently for 30 years and you're expert in it? What made you to come to that profession, sir, in a different way altogether?
Good question.
Yes.
As you rightly said, we are all in the profession as advocates. But mediation is not something out of that. It's a continuation of that. You have been practicing for so many years, having known law to some extent. Now we are taking a slight deviation from that to see the perspective from a neutral point of view, neutral third person's point of view.
Okay.
Therefore, you have been on one side of the law, either representing one of your parties. You would not have been knowing the other side because that perspective is different. Now in mediation, when you are in the neutral, you see both perspectives.
Okay.
So it is not a different ball game altogether. It's only a continuation. And as you have been already a part of this system, this is only an additional dimension to you.
Okay.
So the mediation is something which is a new thing, which is a good thing which is happening in the Indian judiciary now. So therefore, I don't see it as a separate thing at all. It's a good change, I would say.
But how was your how was the start of your journey, sir? When you came to the profession, even because every law student will be having the dilemma. Should I have to go for the criminal? Should I have to go for the civil? Should I have to take all the cases? Should I have to go for the corporate? Did you have the same kind of mentality when you got into the profession, that confusion?
True. It happens in everybody, whether it is in this profession or any other profession. Because we think that it is a profession. Once you come, whether it is civil, to join a criminal practice, to do criminal practice, or to go to the High Court and practice directly. These are all the dilemmas everyone passes through. It's a good thing to also happen. Maybe at that time I had a exposure to some persons whom I should always now respect them. I came into this field where I'm mostly into civil practice, slowly into ADR practice, alternative dispute redressal mechanisms, then slowly into this new concept, which is also now almost 20 years, 25 years old as it is. So it's a mediation concept. So there was nothing much, difficulty for me to opt to this.
When we say mediation, and as our textbook says elsewhere, alternative dispute resolution. So there is a mediation, there is a conciliation. So there are, things which are in the same report, but they are entirely different altogether when we go in depth for that. So can you explain if somebody who's watching our show who's not sure and who thinks, arbitration, conciliation, mediation, altogether three as a one. Can you explain it in a simplified terms for them, what it is?
See, arbitration, conciliation, Lok Adalat, you must have also heard of this.
Yes.
Judicial settlement, mediation. These are the 5 dimensions in alternative dispute redressal mechanism. That is to say, you have the existing judicial system. In addition, these are the 5 different alternatives which are now introduced.
Okay.
I can take a different example. You have a road, maybe a congested road. Over years, because of the traffic congestion, that road is not able to, the people are not able to use it effectively because there is a lot of congestion. The traffic density is so high. The municipalities or the authorities who are concerned with that will not keep quiet. They may find one deviation from there to see that one set of people who want to go to a neighboring place can take a deviation and maybe go by a flyover. Maybe another one to see that somebody goes in an underpass. Maybe another one where it goes and joins some other major road. So the idea is to see that decongest the main road and find alternatives. So like this, arbitration, conciliation, mediation, judicial settlement, and Lok Adalat are all alternatives to decongest the judicial system, the load on the judicial system. Having said that, arbitration, mediation, conciliation, they are totally different mechanisms. For an outsider, it may think it's only an alternative. But if you have taken the left median, left road, it goes to one destination. If you go to the right one, it takes you to the other destination. So you can't say that destination on the left and the right are the same. So they're all different, destinations you reach. Similarly, in mediation, it has its own principles. Arbitration has its own principles. So every mechanism under this alternative has its own principles and serves different purposes. So like a doctor who diagnoses and sees as to what is the root cause for the disease and guides the patient in a particular treatment, it is a case where you as a lawyer will be able to diagnose and see what is the best remedy for your client. Maybe in one case arbitration, that's an alternative. In some case it may not be an alternative and it may be conciliation. In some other it could be mediation. And I don't say that every case is fit for mediation. Some cases are good to be in the court itself.
Okay.
So firstly, what we should understand is all are different mechanisms, though called under one heading of ADR.
ADR, yes.
Each serves different purpose.
Yes.
Each has a different prospectus. So it moves differently.
Okay. So mediation is something, do they use it on the family matters especially? Like if you have to classify mediation specifically,
yes.
Yes, that goes for the family.
It is also for family matter. It is also for many other matters. Anything civil, wherever there is two human beings, two human minds, mediation can work.
But I was doing a research on this. They say you're a threat for the lawyers because right now in India, they have passed the Mediation Bill of 2023, but they haven't implemented it. That's one more topic. But if all the people start going for the resolution, directly for the mediation, and skipping the 10 to 15 years of court hearing phase, every hearing a lawyer must be getting certain amount of fees. But if they get sorted out their problem within a month or so through the mediation, don't you think it's like directly attacking the lawyers who's making on the bread and butter?
No, it's
what do you want to say about it?
It's the other way.
Okay.
Doctors are also there to cure. Doctors are all there to prevent. So the preventing is also done by the same doctor. Cure is also given by the same doctor.
Yes.
So here, the litigation is also by a lawyer. Mediation is also by a lawyer. So in fact, I would say it's a double edge. I mean, advantage.
Yeah, got it.
Both. When you get both, you can be a litigant advocate. You can be a good mediator also. A
But
huge
sir,
scope for us.
yes, sir. But sir, I mean, I was studying the mediation bill which has been passed, and at certain topics, I felt they're kind of like trying to bring in this American system of where the mediation will be made compulsory before they go for the litigation. I mean, before they go approach the court.
Yes.
But they also say mediation should be done by two people who are willing to mediate, who are
Yes.
willing to come across the table.
Yes.
But if you force the people to the table, don't you think it won't be serving that purpose altogether?
No, I don't think it is called as forcing. It is for you to. It is compulsory for you to attend the mediation session, but simultaneously, it is not. It is voluntary for you. It's like saying, you have to take a left turn here. You can't go to the right side because the traffic requires that you should take to the left. But once you take to the left, you can take to any side, other side. Or you go to a shop. Compulsory you have to go to a shop, but buying is free. In the sense, you need not buy. You can always buy. You need not buy. Just entering the room is important.
Got it.
Maybe that by entering, you may also choose to continue to be in the mediation. So there is no compulsion in mediation. That is exactly opposite of what happens in the court.
Oh, okay.
That's a big fundamental difference between mediation and the court. Court, you have no choice. It's compulsory. If someone comes, you have to attend.
Yeah.
You means the litigant.
Yes.
In mediation, you can choose not to go.
Oh, okay. And I mean, you have done your mediation course in California, if I'm not wrong. So, what was the one major thing which you found different that the mediation in India, which we are not following, and mediation in Western countries, they are following? Is there any specific aspects?
We did it in Bangalore because those people came to Bangalore and we were trained in Bangalore, Karnataka.
Oh,
In
okay.
Karnataka.
Okay.
It was through the initiative of the Supreme Court of India.
Oh, okay.
So their trainers had come from California. So it was done here. Not much of difference. Having said this, that not much of difference between the two. Only thing is we have to Indianize it. Some of the things are in California or USA could be different. There, the cost of litigation is probably 100 times costlier.
Yeah.
As compared to litigation in Bangalore or India.
But in America, if somebody wants to be a mediator, if they basically do a course, they can handle a mediation case. In the sense, they can mediate the case. But in India, that's not the scenario. You have to be, certified. You have to be recognized. You have to have a certain kind of experience. Don't you think we are bringing in red tapes already for the mediation as well? What's wrong if the person is able to find a solution? Does this age have to matter?
They are trying to introduce certain basic requirement for a mediation. A mediator has to know the law. Finally, the settlement which is signed by the parties has to be within the four corners of law. So therefore, a fundamental knowledge of law is required. That fundamental knowledge of law comes to you by practice. And it is presumed that it will be by 15 years of practice, you would get that knowledge. You'll also be matured in life. You'll also probably have exposure to life, practice, general life. So you will be able to be a person who can probably sit there and probably officiate as a mediator. You are a personality by yourself. That also draws the attention of the litigants.
What are the qualities of the good mediator, sir? Because across 30 years of experience, it's a huge time. You must be basically studied the human nature altogether.
Yes.
You have to basically read both the parties where you can find that solution. But can you tell the major thing which is a must for a mediator if somebody is choosing this path in the law?
A good communicator.
Okay.
Mediator has to be a very good communicator. Make simple sentences, effective sentences. Also to study other person. A good listener. A good listener is 50% of mediation. That's all. And a neutral platform is another 50%.
Yeah.
So when you start listening, automatically you become, close to the other side, close to your party. So they feel that, there is a man whom I can trust. So that's 50%. Other skills, you can always learn it. This is something which is not easy.
Oh, listening.
Listening is not easy at all. Most difficult thing is listening.
Right? Everybody wants to speak.
Yes. Non-judgmentally. Listening without any, prejudice.
Yeah. Be curious, not judgmental.
Yes, you're right.
Yeah, we have to be curious.
Yes.
The person has to be curious.
Yes.
Okay.
to get more from you rather than I communicate more to you. So this is one thing which is different in the lawyer and the mediator. As lawyers, we speak.
Yeah.
As a mediator, we listen.
Exactly. So that's the reason I asked you. Like, you're into altogether a different thing over there. But what is the, I mean, if somebody is going for the mediation, and I mean, at the end of the day, I know it's finding the middle ground. But middle ground, I feel it won't be always the 50-50. Like, I mean, it may be 60-40. I mean, either of the side. What is the major mistake which the people make when coming to the mediation or when they are in the mediation? Like, they
You mean
make.
to the parties?
Yeah, parties.
They think that the mediator is also some officer appointed by the government. So he is there as a official authority and is trying to impose his views on us.
Okay.
They would have probably gone to a police station or some of these, the conciliation centers, so-called conciliation centers, so-called mediation centers. Please note there is a difference between middleman and mediator.
Yeah.
They confuse the middleman to be a mediator. So they would have that experience and they think that that is how mediation is. Mediation, the mediator is absolutely a neutral person. He has no contacts at all. He doesn't know the party. So he comes to know of them only in the process of mediation.
That leads to me one more question. The basic idea of this podcast is we felt that lawyers aren't getting the recognition which they deserve. And I started doing a bit more research on that. And we actually spoke about it in our first podcast as well.
Mm.
In India, less than 10 to 15% of the people know what is law. Whatever happens, they'll be knowing only to pay the bribe and leave. They won't be knowing a law. A simplified law as well, they won't be knowing it. And I found, I know this may be a bit kind of like an evolving this thing or else kind of like an outside of the box of thinking. The basic problem which I feel is that if we go for America or the majority of the Western country, the lawyer will be advertising themselves. I know Bar Council doesn't allow us to advertise.
Yes.
And over there in America, they'll be advertising themselves as something called as Better Call Saul, legal trouble, call me. And that makes that lawyer to be recognized. Like they advertise. But in India, we have that 8 lamps of advocacy and the law is known as a noble profession. And that's the reason I got to know that we aren't supposed to advertise and Bar Council doesn't allow. But I would like to contradict in that regarding that point. The basic professional ethics when we were studying, they said that earlier the people used to practice law was from the higher class of family who had that kind of a luxury and they used to fight for the people or the poor side of the people. So they used to do it as a noble profession. But I think we have evolved much more than that. Don't you think, sir? Because what's wrong in lawyers advertising themselves? Like lawyers, majority of the lawyers who spent their entire lifetime, 30 to 40 years, they won't be coming up for the limelight or, not everybody wants that limelight, but at least the fraternity. Don't you think we have to move past of that kind of a colonial era or law or something where the lawyer should be given some kind of kind of like an exemption or something so that they can advertise or else they can, market the law itself, because lawyer won't be marketing himself altogether. The law will be known to the people as well. Why do you think that is happening? Are we still in the era where we think the law is or the lawyers should has to be that noble profession itself or the higher class people itself?
I think there is an answer in your own question.
Yeah, sir.
The law can be advertised, not the lawyer.
Okay.
Mediation can be advertised, not the mediator.
Oh, okay.
See, similarly, I am of the school of from the old thought, where the lawyer has to be advertised by the client of his own. A client is the best person to advertise about the lawyer.
Yes.
If you happen to be my client and you are satisfied with my services, you would go around conveying to saying that there is a man here whom I know. That would be the best advertisement. Whereas if I start advertising, there is no end to it. It will lead to unhealthy practices.
Okay.
So I think what has been set in the Bar Council, the rules, I fully agree with that.
You completely agree.
We should not be crossing that line.
I guess that's the where we are kind of like trying to differ. What's wrong in advertising? Why do you think we shouldn't advertise ourselves?
How do you know that what I am advertising myself, I am up to that mark?
Okay.
I'm not. Advertising once exaggerate.
Yeah, got it.
How do you know? Where do you draw the line?
But that goes for every advertising, right? Every brand, every product goes with the same way.
But this is something not a market product.
Okay.
This is where the life and liberty is involved.
But it's always, we are in the service sector altogether. Don't you feel?
True. Even then, I would say doctors, lawyers, they should not advertise. Even I'm seeing that some doctors are advertising now.
Yeah.
That is not correct.
I mean, if you go for some practo or some kind of healthcare apps or something, the doctors will be advertised like
Yes.
this many of your experience, this many of, I mean, like,
Yes.
I know they'll be doing with some kind of loopholes or something. I thought, why shouldn't the lawyers be getting that kind of a recognition? Like, I mean, that was the idea.
No, that may not be very appropriate. It will lead to a lot of unhealthy practices,
Okay.
which is already leading to some unhealthy practices.
Hmm.
So I think there should be some restriction on that.
Okay. So, being in the mediation, this thing from the past 30 years, sir, can you give us a case where you felt, okay, can this happen? I mean, some kind of, as a lawyer, every lawyer will be having a story. So the case which must have kind of like questioned them something. Like, this is the gravity of this case. And altogether, there might be a case where you saw a different ending, which you never expected of. Can you share any bit of that kind of a story with us?
I have quite a few, but if you have asked me, I remember the one which I probably did at the first few months of my beginning as a mediator. I remember a case when there was one landlady and a person who was supposed to purchase a property from that landlady.
Okay.
They had a dispute. They had come to mediation because landlady who had agreed to sell the property and the purchaser who had agreed to purchase, they had entered into an agreement. Everything was drawn there, how much has to be paid, when, what are the requirements to be done. Almost completed.
Mm-hmm.
The last few milestones were not completed. That was also probably done in some time. There was some delay in the process of the A1. The scheduled time was, say, 3 months to complete the entire process. It took little more because of the various other reasons.
What?
One day, the purchaser came and said, please come, we'll go for registration. Tomorrow, I'll send my driver.
Mm-hmm.
Then the dispute started.
Okay.
I don't know. Then it went to police station, some advocates, and finally it happened. It landed in a court. And from the court, it came to mediation. This is a senior lady, probably a family which is in Bangalore from last few 100 years. And she has inherited certain properties from her ancestors. And she claims to be from a very big family. This man, the purchaser, is a businessman who wanted this bit of land from this land and for which she had agreed to give. We discussed for a long time about 3 sittings, 5 sittings. I didn't find any serious difference between the two. We have this concept of private session, where we sit with one party at a time and the other party will be outside.
Caucus session or something.
We call it private caucus, private session.
Yeah.
Same thing. I realized that the day when the registration was to take place, 2 days back, this man has called the landlady and said, I'm coming and picking you up on such and such a date at such time. I'll give you the balance amount at that time. Please come with me to the sub-registrar's office for registration. That morning, what happened, this purchaser was not free. He sent his driver.
Oh.
And that driver came and said, Madam, you're supposed to come to the sub-registrar's office.
Oh.
She felt, I am so-and-so, daughter of so-and-so, granddaughter of so-and-so. I am giving this property to him for a small amount.
Okay.
And he doesn't come and he sends his driver to me to come and go take me to the sub-registrar office. I will not come.
Oh.
This was only a dispute. Somehow it triggered into a big dispute. They were not able to reconcile, so they had come to mediation.
Okay.
Then I had a private session with the the purchaser. Then I asked him indirectly as to what was the reason and how you found that, this dispute emerged. He also said on the day of the registration, I was so busy, I couldn't go to her house. I had a driver whom I thought he can go and get her to the sub-registrar's office. And I sent. I don't know what happened after that. She did not come. And we met only in the police station thereafter, after a few months. Please note, by then it has already, court case has dragged for almost 3 years. From that day to the date of court. And from there to mediation, another 6 months. So 3 to 4 years had lapsed by then.
Oh my God.
Then he realized, probably if I had gone instead of my driver, probably she would have come. I confirmed with this lady again in the private session. She said, yes, I was only expecting him to come and pick me up. That's all the matter. Both agreed. I'll come back on such a date. I will take you in my car. I'll take you to the sub-registrar office, pay the balance. I'll drop you back to your house. She agreed. Matter was resolved.
I mean, these kind of cases, sir, what makes you feel like, the humans
Now
are
that,
so...
that lady was expecting some respect.
Huh.
She thought that sending somebody else instead of himself was not appropriate. Maybe the language he has used, the manner he has come and this thing, or the communication somewhere it failed.
Yeah.
That made her to think so. She thought that she is giving a property for a small amount because she had liked that purchaser.
Got it.
And she was expecting him to acknowledge it and come and take her.
Yeah.
But it took 3.5 years to understand that, and it all ended later with just one visit of this man going to her and taking her to the
But
service office.
I mean, is there any tips for a law student or any youngster? Because I feel more than mediation, you'll be studying human beings. Like
Yes.
the story which you told, oftentimes on a daily basis, maybe we'll be overlooking it. Kind of like we feel we often take few people or few of the close friends of ours
Granted.
for the granted. Like, and that maybe not be intentional, but we feel, okay, I know that guy for so many long years.
Right.
I know that person for so many long years. And sometimes that may be the breaking point for any relationship or something. Like, what do you, can you give some kind of a tips or some kind of a suggestion which we can follow or do so that we won't be landing in whether a legal or personal listing, that kind of a trouble?
See, as between two persons, it's again communication.
Okay.
Effective communication, no quarrels.
Mhm.
When the communication fails, everything builds around it.
Okay.
So the best thing is have simple, effective communication.
Okay.
As human beings, we expect that. So clarify at each point whether I'm doing it rightly. Is it okay for you? Maybe your friend. As you said, we take you for granted. You take your own family members for granted. You take your colleagues for granted. You take your friends for granted. It's okay when the communication is good, relationship is good. For some reason, if it breaks, it all builds up to a conflict at one way. So best thing is to have the effective communication skills.
Okay.
Automatically, the things will be resolved.
What if somebody is not good at communicating? Like maybe maybe let's go for the law student itself. What if somebody who knows the law, who knows exactly what to do, how to do it, but is not good at communicating? Because lawyers, the communication is the major skill, right?
Yes,
What should they do?
they have to learn.
They have to learn.
It's not difficult. It is not a rocket science. It's a basic thing, basic human requirement. You deal with your people. You are not only you deal with every day to day, you deal with so many people in your life. Your neighbor, your friend, your auto driver, your cab driver. Everywhere communication is important. So you have to only make simple sentences, short sentences. Don't complicate your sentences. That itself is a communication skill. A good listener, as I said, good listening is itself a good skill.
Okay.
People like you if you start listening. If you talk, nobody listens likes you.
Right?
Everybody wants to be heard.
Yes.
So be a good listener. That itself is an effective communication skill. When I listen, I get so many things from you. Uninterrupted when I listen, you also feel like expressing freely with me. Don't be judgmental.
Yes.
That itself is another skill. So if you just go open a communication skill book, if there are 125 qualities there, learn 5 of them, that itself is enough.
And going to the mediation and how it is evolving, the major cause for the mediation in India is that because our judiciary is literally clogged. It's like, let's say the Bangalore traffic or Mumbai traffic. It's like, if the person goes over there in Kannada, there is a quote. Somebody I heard it's telling, if you go for a quote, sotonu geddonu sota, sotonu satta. In the sense, like the person who win has lost, but the person who has lost is dead. There isn't any kind of coming back. Why is it happening, sir? 10 years, 15 years, at least the average span is like 7 to 8 years. If they do it on a continuation basis, from the trial court to the Supreme Court, it's like 8 years, it seems average. Why do you think when the person comes knocking the door of justice, the justice is so much delayed over there?
There are many reasons. If you want, we can go on. It's another 2-hour subject. But finally, I say everybody is responsible. Okay. Me as a lawyer, you as a young budding lawyer, somebody as a judge, all of us are contributing to it. Plus, population. The ratio which is required is, one judge is equal to 500 cases. We have breached it long, long back. Each judge in our courts is dealing with 3,000 cases as against his capacity of 500.
Oh, okay.
Court judge, how does he handle? And I would definitely say, yet the Indian judges are the far more better than, are probably the best in the world, because they work under that pressure and still deliver justice. I was told in other countries, the cases are about 10 in a day.
Yeah.
Or in some other courts, 3 in a day.
Yes.
Whereas we have 250 in a day. We have some of the judges who deal with 500, 600 cases a day. They are at 10:30, they are at 5:30. Some of them sit up to 6 o'clock in the evening, go back and work again in the night. All night they work, come back fresh in the next morning. They don't carry any of these pressure the next day. It's something which is not, as I said, it's not 1 minute which I can say.
Yeah.
See, population is increased by at least 3, 4, 5 fold in the last, 2 decades. Number of judges, appointments are not increased that way.
Yeah.
And appointing the judges itself is not the solution. Appointing the judge doesn't mean that appointing one judge or 10 judges. You have to have the infrastructure for 10 judges.
Yeah.
Which means each judge, I'm talking of a high court judge, requires at least 15 staff behind him. One driver, then, stenographer, at least they need 4 stenographers, one big infrastructure, court hall, building, all the paraphernalia. So the cost on the government for appointment of one judge and his complete court hall would be in crores. So you can't have number of courts. And finally, also increasing the number of judges has not decreased the number of cases. It is further increased.
Yeah.
So it is not that, the system is such. It's also a healthy sign, I would say. People still have faith in the system. They are not resorting to anti-social methods. They are resorting to, they are coming to the court. They are getting relief.
Yeah.
So many people are happy that, they are getting relief. We say on one side it is taking years, but they are also happy because they are getting some quick reliefs. So I would say pendency is a big subject. All are responsible. That's where exactly, again, you are hitting back to the same subject. These alternatives are to be tested or tried.
And I was going through this, Big Bazaar case. Reliance Industry Limited was Amazon, like Amazon had bought. Have you studied about that case, sir?
Yeah.
So, I was going through it, and somewhere the Supreme Court said that the mediation has to be referred to the Singapore, because the Singapore has become a mediation hub right now. India being the biggest population in the world, why aren't we achieving those kind of things? Because the word goes for Singapore if there is a major mediation happening. Why it is not happening in India? Like, why can't we sort our own mediation in our own country? That don't we have that kind of an experts or that kind of a law which backed up? What is missing over there?
Maybe it was a choice of the party. I do not recall it now. See, what is the difference between a court and a mediation is, court, you have no choice. You have to come to X court only because of the jurisdiction issue. Choice of a mediator is that of the party. See, party autonomy process. So parties must have chosen Singapore. You are right. We have good mediators here, very matured, competent leaders, bar members who are mediators here. We have the retired judges here who are good in mediation. That could have been done. Probably they did not know. They may probably have chosen that.
No, sir. The majority of the mediations, like I was doing a study, and many of my friends as well, if they are getting into the mediation, they're trying to get a internship in Singapore. Obviously, if they have if they have that kind of a backing of the money, they're planning to do it in Singapore. And the major reason Singapore being that is they have very strict law regarding the mediation. Second, the mediation experts which they have, and that country altogether itself is a neutral country. They aren't allied with the Western, or else they aren't allied with the Russia or China or something. Geographically, they are allied with everyone. So nobody's against them. And when it comes to that kind of a position, India has been like that from past 10 years at least. Like when the Western country has sanctioned Russia, that they can't sell their oil, India is literally importing the oil from Russia, and they're selling it for the same oil for the double price for the Western country. which the Russia used to supply because of the Ukraine war. They cutted it out. So when that is happening, we are already there. Even right now, the mediation bill which has been passed, it has been implemented yet. I mean, it's passed in 2023. So have you got? Did you had an opportunity to go through that bill, sir? I mean,
Yes, I have. I've
so
done it very
what is your
extensively.
input on that?
There are good things there.
Okay.
I would say there are so many new things which are, I would say, conceived there.
Mm-hmm.
There are some things which could be improved.
Okay.
So that area, probably there is also some fundamental thing which I would not like to disclose now, which probably is something which has to be worked by the government.
Okay.
I am told that the government is looking at it.
Okay.
That may even hit the base of the mediation itself. That's my fundamental thing.
What is that? I mean, like if you can share.
It is something which I would say they are privatizing the dispute resolution process.
Yeah.
Hitherto, it is all the courts which were doing the dispute resolution.
Mm-hmm.
Now it is being given to the private people to do dispute resolution. Probably there has been some more restrictions on how and who has to do the private dispute resolution.
Do you think it's a bad idea of getting the private?
Yes, that's my personal idea.
Okay.
How do you check the integrity, credentials, or the competence of the person who is sitting there? You may have your own body, calling it as Mediation Council of India, giving them some conditions, restrictions, and imposing certain terms. But how do you, on day-to-day basis, how do you check it?
Okay.
It's like in a private hospital and a government hospital.
Okay.
Maybe government hospital may not be, is up to the level. But still government has some control over that. Whereas a private hospital, they have no control. Similarly, this will be a private court versus a government court. Government court means it is a judge who is appointed by an authority.
I guess it's more or less goes like something like, let's say, consumer court or something, right? Because the consumer court...
that is after effect.
It's a quasi-judiciary or something.
Correct. It's after that. If a mediator fails to do service, then it could be a consumer. What till then?
Oh, okay.
So dispute resolution, I think they're trying to change that private resolution process into something sort of a tribunal. This I'm not very sure. Therefore, they're holding on to it.
Oh, but I mean, I feel like, I mean, the other perspective, I feel like, I mean...
I'm saying this also.
Okay.
We'll assume that today, 1,000 cases are filed in a court. We'll take one district. Maybe we'll take it as Mysore. In Mysore, 1,000 cases are filed in a month. Now, Mediation Act has come. People want to opt to mediation. So these 1,000 disputes will not go to the court. We'll assume only 500 of them will not go to the court and they want to come to mediation.
Okay.
Where is the infrastructure? Where is the infrastructure? Government has no mediation center to cope to this 500. Private mediators are not still recognized. So unless you have a system ready, infrastructure ready, competency, everything being there, you can't enforce a law to say you go for private thing.
Okay.
Courts are always there.
Yeah.
You can always rush to the court. But if you go to the mediation or the judge says go to mediation, where do they go? So they have to do some fact checking.
Okay.
Due diligence of each one of the person.
Mm-hmm.
And who are the persons who are doing it? Is he an advocate?
Oh.
Which means he's also a practicing advocate. Does he devote full time to mediation? If 500 cases come to mediation in Mysore, how many mediators are ready to handle that?
Okay.
Maybe there are 10.
Mm-hmm.
Next month, another 500 adds up.
It becomes one more. It becomes one
this
more.
Becomes another
You're
system. Yeah. See, probably these are the reasons. It's like, a situation where you have the hospital, you have all the best of the medical equipments, but you don't have the doctor. So the government has to get up to that.
Okay.
Appoint people, maybe institutionalize the whole process of mediation, keep check on their credentials, and probably appoint and send this thing so that we have the track record of all of them. Because finally it ends in a solution.
Okay.
It ends in a dispute resolution, which has to be according to law.
Okay.
So it has to be, tested by somebody. So probably this is the reason why they are still holding on to it. They're wanting to probably streamline this to see that, there is some body set up as a tribunal, called it as a mediation tribunal. This is what I've heard, but I'm not very sure about it.
Okay.
Anyway, we're expecting it in this session of the budget.
Yes.
Parliament session of the 2025 budget session.
Yeah.
I don't see so far.
Yeah. So, I mean, is the mediation kind of like a next big thing? Do you think because of the case loads?
Yes.
How does
Mediation is the only thing which is happening in the judiciary now.
Okay.
That's the only reform I would say.
Okay.
And that's a big thing.
Okay. So, I mean, if let's say if somebody goes for the mediation, they'll go through the process. I mean, 7, 8 the sittings, everything will happen, and they will agree upon a terms. Can they back out after that?
Presently, the mediation which is done, there are 2-3 types of mediation. One is a court annexed mediation, which means the court, there is already a litigation, which goes to mediation. Mediation, in the mediation between the two parties, we call it a court annexed mediation, resolves a dispute and that is drawn into a settlement. That will go back to the court again, the very court, and the court checks again to the nitty-gritties of that.
Okay.
Then it certifies. So there is a responsible judge who sees the entire terms, sees whether it is in the four corners of law. Yes, then only he will say, I will sign this.
Okay.
That need not have to be rechecked. Suppose it is a pre-institution mediation, which is another concept, which means it is not a court annexed mediation. To simplify, even before going to the court, you can go to mediation. It is like a clinic.
Clinic, yeah.
It's an outpatient ward. You are not getting into the ward, namely court. In an outpatient ward, you are getting treated. And the doctors treat you and say, you're all right. There is no need to get into the operation or the hospitalization.
Yes.
So pre-clinic is something before you go to the court.
Okay.
That also you can have a settlement.
Okay.
That settlement is not checked by anybody. It is only the mediator and the two parties.
Okay.
So same mediation, if it is court annexed, it is checked, confirmed, ratified by the judge.
Have there been any cases where when the mediation has been settled and it goes for the court and the court says, no, this terms cannot be happening. The law says, yes, it will happen.
Yes.
And
court is a final authority.
Final authority.
The judge sitting there, he has every right to be satisfied. Does these terms agreed between the parties are correct or within the four corners of law, lawful?
But don't you think, sir, that will lead to one more a bureaucratic red tape of going through the entire process only to come back for the, same problem? Like,
yes, but sometimes it is required because mediation is done under the guidance of the judge.
Okay.
In the sense, mediation is a shadow of the court.
Mm-hmm.
So these mediation, that's why I'm saying the court annexed mediation is sent by the judge with an understanding that, the people go through the process and comes back to him. So he outsources the work.
Okay.
The judge there, he doesn't do it himself by rendering judgment. He outsources his work to mediation through a mediator in a neutral third-party forum, and he keeps control over it. In the sense, once it comes back, unless he puts his final signature, it is not confirmed.
Oh, okay.
So in some cases, it is required.
It's required. And what are the, majority of the case when it comes to mediation, there'll be family, there'll be commercial dispute, there'll be, various kind of disputes. What is the major number of cases which you have handled in the mediation? Like,
family matters are more.
Family matters are more, is it? Okay.
And there are quite a few civil matters.
Okay.
Civil disputes, partition disputes, money recovery disputes.
Oh, okay.
Then property claims, rival claims on the property,
Mm-hmm.
boundary disputes.
Okay.
I say that, you have encroached on my property. These disputes are there. Every nature, trust matters, company matters. Some company matters also have some dispute. As I said, wherever there is two human beings and two egos, mediation can work.
Coming to the family matters, sir. Many of the guests, we actually, this has becoming like one of the topic which we speak with many of the, most of our guests over there. Because we get requests to speak regarding that topic, and we are getting the NRI people contacting us. The 498A, the dowry harassment. Did you read about the Atul Subha's case which happened? Like, I guess people have forgotten about him right now. So it's been like 3 to 4 months. Like,
correct.
There's a current trend. Even 2 months ago, there is one more guy, I guess in Asan or something, who committed a suicide because of the case which was filed against him, and he couldn't take it up.
Correct.
So many of the NRIs, people who are in England or something, even they are facing this issue. So I got calls literally from those people asking to specifically concentrate, do and one full episode on that. But I don't want to go in depth because, as you said, you handled the family mediation. What do you think is happening on the current scenario? Because we have an understanding that the rural place of India, still the dowry harassment and certain things are happening. But on the urban area, it's other way around. The male are kind of like becoming a victim. What is your input on that?
It is both ways. It is not that always male or you are saying male or victims.
Male or becoming kind of, because Atul Shubha's case is
it is one case of such nature. It could be the other way also, where female is a victim. See, it again depends on facts and circumstances of each case. Unless you know, give active listening to the two parties, you won't know who is right, who is wrong. And it is not for a mediator also to know who is right, who is wrong. It is for a judge to decide whether male was right or female was right. For a mediator, there is nothing as right or wrong. He only sees what is the meeting point between the two of them. So I never see it as who is dominating or who is the victim. I see what is a point where they can be understanding each other. So I never see, when I sit as a mediator, I'm not an advocate. I'm not a judge. I only see what is the point which could probably trigger a solution.
Okay.
So what you say, suppose you say 2 plus 2 is 4, or you say 2 plus 2 is 6. I believe so. My input is 0 there. I know. I am also undergone your this thing to say, I have learned mathematics. I know 2 plus 2 is 4. But when you say 2 plus 6, I will not disbelieve it.
Okay.
I will listen to the other side. If he says 2 plus 2 is 60, I will also not disbelieve it. My only idea is to see that 60 and 6 become closer to each other. That's all. My input that 2 plus 2 is 4 is never going to be told to them.
I mean, why do you think, what is the current trends? Are like, are the divorce cases are kind of like increasing in this thing?
Yes, yes, but compared to many other countries, I think it is only, as I was reading somewhere, it is just 1% of the marriages which is happening.
Okay.
So which is not very serious.
Okay.
But yes, it is alarming. The divorce cases are on the increase.
Any tips for a youngster who is about to get married or something? Like,
be a good listener. Be a good communicator.
Okay.
Again, that's all.
That's all.
Yeah, that's a.
Majorly
that's a lesson for life, not just marriage.
For whatever the profession which they go, that has to be there.
Yes,
they have to be very good at listening.
See, believe that there are perspectives. If you ask me, there is nothing as right, nothing as wrong. The circumstance is important. You did this because of these circumstances. When I understand that you did this for this circumstance, maybe I also say yes. In his situation, I would have also done the same thing. So the context has to be seen. So that is where mediation allows you that perspective.
Okay.
Understanding the perspective. So when you are sitting before a third neutral person and given an opportunity to talk to each other, and when both of the two talk to each other, they come out with their perception. We call it drishtikona.
Oh, okay.
Maybe he will also understand, okay, now I understand that this was the reason. Please note, in our present day, at least social platform, there is no occasion when you get to make the two of them sit in a neutral place before a neutral person. Mediation is key. Mediation is working because it is between neutral persons. Before a neutral person, in a neutral place.
Oh, okay. Got it.
When we say mediation, it will be usually in a house. Coming back to matrimonial cases, it would be usually in an uncle's house. Uncle close to the boy or uncle close to the girl. So one of them will not be comfortable because it is his house or his relative's house.
Okay.
So when you do it in a neutral place, it has all the advantages. Okay. So mediation allows this to happen. When you let out your feelings, express your thoughts, anguish, anxiety, naturally they understand each other. All the animosity or the unwanted things will be wiped out. They come to real terms. Oh, this is the reason why you did not agree with me. So agree to agree is possible when you give them some opportunity to understand each other.
Oh, okay.
Otherwise, agree to disagree. That's also good.
Yeah.
A serious disagreement? Yes, thank you very much. I agree on this, I disagree on this. Mediation recognizes that also. So agree to partly agree to partly disagree. Agree it. Arrive at a settlement. Disagree? Thank you very much. You have the disagreement. Go ahead.
And sir, I mean, like as we were discussing earlier before the show, do you want to share it? Like you were, I mean, you had written about the how the India should be having a one judiciary body or something, and you were working on it. Like you were actually written people about it. So can you explain what exactly is your idea on it, and how do you want to implement it? Like if you have a given, like what is your exact thought on it?
See, we have so many laws which are state laws. Some of them are central laws. The state laws are to the respective state. For example, I'm just taking an example. Anyone who wants to file a case in a court has to pay a court fee.
Yes.
It's a required court fee because you have to pay to the court for the institution of the court, running of the court. We have the law which will be probably one in Karnataka, different in state of Tamil Nadu or in Orissa. So there is no common understanding. So court fee being standardized all over India for all the disputes itself is one good development. So we can look at one India, one court.
Okay.
I'm just giving a small example. Rationalize it. Anybody wants to approach the munsif or the civil judges court, fix, safe, 200 rupees as a court fee. All over India.
Okay.
So even if I'm sitting in USA, I want to litigate in Bangalore, I know that the court fee involved in India is 200 rupees for a civil court case. Suppose it is a family court case. You work out the statistics. I don't know how it will be, cost factors and all that. Fix it as 250 rupees. That's the end of it. You have it in one place 250, in another place 25 rupees.
Why do they do that?
Because it's state law. Each state has enacted its own law. There is no common point there.
Don't you think if they try to implement this, they will start questioning about this federalism altogether, that the states have that autonomy and states have that kind of an own right? We cannot.
I don't know. I don't know much about that. There may be debates on that, but finally you have to have it simple.
Yeah.
You're looking at somebody who has to have hassle-free process.
Yes.
He should know that he is paying this. I'm just giving you one small example. Take out these jurisdictions. Why you need jurisdiction? You are in Mysore, I'm in Hyderabad. Suppose there is a dispute between the two of us, whether Mysore court I have to go or I have to go to Hyderabad. Make it the court which they want to. If they are not agreeable, then fix one of the court, alternative. Suppose both of us agree and say, okay, we'll have it in Kashmir as a jurisdiction. Go there. So, I mean, there are so many things which can be worked on. I'm just giving an example. Court fee is one thing which can be done. There are so many other laws which can be simplified so that, slowly we can normalize and bring it as one law, one court. One court, one nation.
No, I mean, like actually...
One nation, one court, rather.
Yes, sir. I mean, like that's actually a nice topic because, I mean, I have been kind of like interning on the consumer court. That's the reason I keep on bringing it up. And there are two consumer courts in Bangalore. I mean, center. One is near the Shantinagar and the other near that Kaveri Bhavan. But the thing is, those two courts have altogether a different set of formula which they follow.
Exactly.
Issue of notice, taking of the evidence.
Correct.
And it differs from court to court. I mean, there is a guidelines, but I think it's not been implemented up to the mark. Why is that happening? Because judiciary being that kind of an autonomous body, and I know it's a quasi-judiciary, not the exact judiciary, but why aren't that kind of an implementation being done so that the procedure will be will be same for all the courts or something?
That's what I'm saying. You have to have a common rules, common process, common procedure. Simple.
Now it has become the jurisdiction of the judge, is it? Like how the courtroom should run for
There are some areas where it is not having any particular rule. So the judges interpret the way they want it.
Okay.
So fill up those gaps. Make it common. This means this. It has to happen this way only. Then that the scope for variation is not there. As you rightly said, between two judges, there is different rules.
Got it.
Because when there is something which is absent in the rules, they set their own rules. That should be stopped so that it's made. I'm saying the same thing. You are talking of two judges in one building or probably one city.
Yeah.
I'm saying make it all over India. So that even if you're sitting there, this is the way you have to do it.
Got it.
I'm also saying the same thing.
Yes. Yeah, sir. So if somebody is a student and is watching this show, and if he wants to go for the mediation, can you explain him why mediation is the next thing, big thing, and how we should get into it, like where he has to practice and what are the things, do's and majorly don'ts?
Okay, good question. See, mediation started about 15, 20 years back in India. It has gained a lot of momentum. And the way it is going, probably the next few, I would say next at least 3 decades,
Okay.
mediation will rule the judiciary.
Oh.
And that's the scope which it has. It has. Probably the average Indian age is now 28.
Yeah.
28 means probably a law student would have just completed law
Mm-hmm.
and probably has started practicing. Probably you are yet
Yes.
to reach that level. So the future is yours. The future is of people who are young, who want to take up law. You said student, I would say law student, they have bright prospect, particularly in the area of mediation. Now the laws are such that mediation is now entertained or being trained only for people who have completed 15 years of practice. Time will be there when they'll reduce it automatically because there will be a lot more youngsters who are wanting to do it. So the government or the body, namely the Supreme Court, may say we'll reduce from 15 years restriction to 10 years restriction or 8 years, which means you start for practice for few years, you can become a mediator. So you can be a mediator, that's one thing. You can be a counsel in the mediation.
Okay.
That also is okay.
Hmm.
See, every lawyer cannot do well in profession.
Yes.
They may have their own inhibition.
Mm-hmm.
There were days when they say, if you're a good orator, then only come to this profession because lawyers means good oratory. Those days are gone.
Mm-hmm.
If you're a good if you have human skills, communication skills, you can be in mediation, even as a lawyer appearing in mediation.
Okay.
We are saying mediation bar. That is to say, you have to have people exclusively who come to our mediation. They may not be appearing in the court. You will learn the negotiation skill. See, what is mediation finally?
Listening.
It is listening, evaluating. So mediation is a facilitative process, which is listening process or a communicative process, and an evaluative process.
Mm-hmm.
So you learn those, which you can learn in 3 months.
Got it.
Adopt to it, learn it. You can be a good advocate in the field of mediation. Slowly you can also become a mediator.
How many years will it take, sir? Let's say if I join for the mediation or thing, where should I go? Should I have to intern under a lawyer, or else like should I have to go for the mediation center for the internship? And once I get graduated, once I get my law degree, how many years will it take to become a professional mediator? I mean, so that
As of now, the rules of mediation are saying one lawyer who has put active practice of 15 years can only apply for mediation.
then how should they survive for the 15 years?
Correct. This is for the court annex mediation. Please note.
Oh, okay.
Court annex mediation. That is to say, court case is already there, which is referred to mediation.
Mm-hmm.
The day is not very far when they will revise it and bring it to 10 years or 8 years. There are other mediations. There is no bar for that age as of now, unless they start putting some age bar.
Oh, okay.
It can be, anybody can be a good mediator. I mean, overnight you can't be a mediator, a good mediator. It takes time. Maybe you do some mediation under the guidance of some senior.
Okay.
Maybe 1 year, 2 years, like internship in mediation. The law will also probably develop accordingly. One who wants to be a good mediator can become a qualified mediator by taking X course for 3 years, then internship for 2 years. Then he can become a mediator.
Got it.
So I'm saying next generation is yours.
Yes.
And mediation is there, which will be probably one of the key changes in the field of law, which will be probably your take for the next 3 to 5 decades. Because India cannot have this adjudicatory process continuing, as is rightly started off saying, so many number of cases pending.
Yeah.
And on the other side, now government is saying, and the rules are coming saying that everywhere they are introducing mediation.
Yeah.
So this is a huge change.
Yeah.
So it requires people like you to take up this
mediation
in a serious manner.
Yes, sir. So any last message for the law students who are watching this podcast, sir?
I would say the time has come for them.
Okay.
This is the right time for the judiciary,
Okay.
I mean the law fraternity. Just Indian judiciary requires you be proud of being an Indian, be proud of what you are. This is your profession.
Yes. Correct.
This is going to be a profession which will be probably there for the next, say, 5 decades. You have come to this profession at the right age, right time, and this will take care of you.
Yes. Thanks a lot, sir. Thanks a lot for coming, Ashu.
Thank you.